Today's topic is the federalism, role of governors and the constitution. To sum up the entire speech which I have prepared, I want to quote Mr. C.N. Annadurai, who was the founder of the DMK party in Tamil Nadu. He once said, "ஆட்டுக்கு தாடி எதற்கு, நாட்டுக்கு கவர்னர் எதற்கு?" Why should a goat have a beard and why should the country have a governor? That sums up the entire functioning of a governor in the last 72 years. And therefore, with this note, I want to speak to you. You will also be very shocked by noting one aspect. Our constitution prescribes various qualifications for various posts. The one post for which there is no qualification, or at least minimum qualification, is a post of governor. He has to be an Indian citizen and 35 years old. And that is how we are having Arif Mohammed and others in this country. He doesn't need any more qualification. And now, when you talk about how in South India, especially Telangana, Kerala and Tamil Nadu, and Puducherry Lieutenant Governor, we have three species in this country. The other two southern states, Andhra Pradesh and Karnataka. Karnataka is ruled by BJP and Andhra Pradesh, Jagan Mohan is yet to know where he stands. In these three states, the central government is afraid that the opposition parties which are ruling in these three states, they can't make even an inch of progress in this state, and therefore the mechanism that they have defined, the mechanism which they have devised is to send governors of their choice. We find Tamilisai in Telangana, an additional charge in Puducherry as a lieutenant governor. Between Puducherry and Hyderabad, it takes 730 kilometers. They could not appoint anybody else except Tamilisai Soundararajan, who is happened to be a medical doctor. Then we have R.N. Ravi, who is a Tamil Nadu governor, who has come from Nagaland. He is a man from Bihar. He has come to Tamil Nadu. He belongs to the Indian police cadre. And that is a qualification to appoint somebody in the Northeast. Today, if you see in the Northeastern states, of those seven sisters states, you will find mostly it is a retired policeman or a retired army general will be appointed as the governor. Because most of the states were governed by Armed Forces Special Powers Act, and therefore they need policemen. Now suddenly from Nagaland, this man was sent to Tamil Nadu. When a constitutional functionary retires or transferred, there will be some farewell function. For this man, he was so notorious, there was no farewell function at all. People of Nagaland were so much despised by the role played by the Ravi, and therefore he is catapulted to Tamil Nadu. Now the question will be, if somebody is despised in some state, does it mean the transfer to some other state is going to in a way make a change? Now you will see these three people, there is some commonality. Tamilisai could not fit into the BJP in Tamil Nadu. And Arif Mohammed Khan was an old politician who changes his color more often. Therefore, best thing they thought was he'll be in Kerala Raj Bhavan. Then you also find the third man, the Ravi. Somebody has to be sent out to Nagaland, therefore you choose Tamil Nadu. Now this is something which is very strange because all the three drawn from different walks of life, but they play a single role of destabilizing the local state government. This is the only assignment they have got before them, and they have no qualms in playing politics in a most dirtiest fashion. And therefore, today when we talk about the role of governors, we will have to think why these three creatures have come to these three states and what is the agenda, what is the brief that they are carrying on. And in that sense, we should understand that the Constitution of India provides for a governor for each state. And how long the governor will continue? Normally 5 years, but there is a provision in the Constitution which says they will continue until the pleasure of the President of India. What is the pleasure of the President of India? President of India doesn't have any power. She or he are governed by the Council of Ministers. Virtually, a governor is controlled by the Home Minister, that is Amit Shah. Today, any governor for that matter, they take their orders either from Modi or Amit Shah, and without which they can never think of continuing in the post. And therefore, if you blame Ravi, you are also blaming Modi and Shah. That is the most important thing. They dance to the tune put up by the Home Ministry, and they cannot continue until they want them to continue. And therefore, they always, his master's voice or her master's voice, they always be there. And when they come to the Raj Bhavan, we should not say anymore Raj Bhavan because they named Rajpath as Karyapath. So Raj Bhavan should be made as a Karyapath. What is the Karyam that they are trying to do? First thing is to destabilize the state government. Second thing is to propagate for the Saffron party, for the Sangh Parivar, act as a spokesman. Thirdly, most of the Raj Bhavan and Raj Nivas have become a party headquarters for BJP of that particular state. Now, who are the people who are being selected now in these posts? If you see some of the past history, there was an RSS man who was appointed in Meghalaya, and the Raj Bhavan women's staff gave a complaint of misbehavior, and he was sent out. It is not only BJP, even previously Congress party had similar people. N.D. Tiwari is a known UP politician, senior leader of Congress party. But within Uttar Pradesh, they could not solve the difference of opinion among the Congress leader. So N.D. Tiwari was sent to Telangana. And for a short time, there was a complaint against him of sexual misbehavior, and he was sent out. Now, how is that when you say a head of state is holding such a high post and where they are going to behave in such a cheap manner, then what is the selection process that is going on for these years? In the initial few years, they were appointing senior Congress leaders who are no longer useful in the particular state. You know, in our houses, when our cow does not give any more milk, we send them to Goshala. The Jains call them as Pinjra Pol, because we can't make use of it, and therefore we send them. Therefore, if a particular person who is no longer used in that particular state politics, he is catapulted as a governor. But some of them, because of the seniority, because of their experience, they were able to stand up sometime, not all the time. For example, one governor in Tamil Nadu refused to sign for the dismissal of the DMK ministry during 1976. Still they dismissed. That is a different issue. But there were cases where some governors were acting independently. But later experience shows that governors are picked up just to go and destabilize. In 1967, for the first time, the Congress party, the Indian National Congress, lost 8 state governments. For the first time, the concept of opposition party in various states started only in 1967. Before that, the Congress party was a monopoly party, and therefore there was no opposition. Therefore, they can do whatever they want. But they found 8 crucial states having non-Congress government. The game of starting destabilization started by sending governors to those states. Therefore, when a governor is sent, either it is to resolve the difference of opinion of Congress party in that state, or a person who is discredited in the state is sent to some other state for his retirement benefit, or with a mission to create problem for the opposition party. It is the 3 objects for which the governors were started being sent after 20 years of the Constitution, and even before 1960, when this game was slowly being experimented. You know, in Kerala, EMS Namboodiripad government first time formed a government in 1958, and the first measure taken by the government was a progressive measure of bringing a law to control educational institutions. The Kerala Education Bill was largely to control the educational institutions which were making money, and also to give job protection to the teachers working in those schools, and also to see a common curriculum is evolved. And therefore, when the Kerala Education Bill was enacted, already the Congress government, headed by Pandit Jawaharlal Nehru, and his daughter was a minister in his cabinet, Mrs. Indira Gandhi was the information minister, they were plotting that how, for the first time, a elected communist government can be allowed to continue. Therefore, against this bill, which has been introduced in the House and passed by the House unanimously with minor opposition, the bill was sent to the governor. Then an agitation was started, which you know, the Vimojana Samaram, where the communal groups which are running educational institutions were scared, and therefore they thought that this government should not continue. Now, normally a central government, which is supposed to be a federal government, should ensure that there is no law and order problem created by any mischievous groups. On the other hand, Mrs. Gandhi was deputed to come to Kerala to supervise that this agitation continues forever, and then they can get a report from the governor that the constitutional machinery has broken down. The government is not able to run within the four corners of law, and a report was obtained, and the Congress party, there was some difference of opinion, but not much. Finally, Nehru succumbed to this pressure, and the EMS government was dismissed. At that time, there was no scope to go to court to challenge when an elected government run by a majority, and much to the disappointment of a central ruling party, how it can be dismissed on the ground there was law and order. There was no judicial review that was contemplated in the Supreme Court at that time, and therefore EMS was went away. The first communist government anywhere in the world which is elected by votes, one man, one vote, and which came to power through a democratic process, was sent out in 1959. Most important event that took place was when the bill was sent to the governor. Under Article 200, the governor at that time, the constitution was not amended. The education was very much in the state field, in the state list, and the governor has to sign or give assent to the bill. Instead of giving assent to the bill, he forwarded it to the President of India. And President of India, for the first time, under Article 143, referred the case for the advisory opinion of the Supreme Court. This never happened. When a state government passes a legislation and sends it to the governor, if the matter comes within the state list, the governor has to give assent. There is no other work. If he somehow thinks there is some flaw in the bill, he can send it back to the House, and when the House passes second time, he is mandatorily has to sign. There is no other power given to the state governor. And notwithstanding that, the matter was sent to the President, which was the most undemocratic step taken during 1959, when the governor office was used for violating Article 200 of the Constitution. And finally, what happened was, when the Supreme Court was hearing the validity of the education bill, it was heard by a constitution bench. The constitution bench answered all the four questions in favor of the dismissed state government. They said there is nothing wrong in the bill, except for minor two clauses relating to Anglo-Indian. The bill was upheld by the Supreme Court. The Supreme Court gave an opinion to the central government. There is no flaw in the bill. In fact, the very famous statement that right to administer does not include right to maladminister. That was the slogan coined by the Supreme Court. Now, when the bill became valid, but the government became invalid, that was the most irony of the situation. The purpose for which the government was dismissed, but the law passed by the government was upheld. This will show the diabolical nature of the central government, where they still destabilize the state government. They go against the wishes of the majority of the House in the state legislature. They make use of the governor to send a report on the so-called law and order breakdown. And they also send the bill so that the Supreme Court gives some adverse opinion, which can be made use of against the EMS government. All the four methods were failed, and finally, EMS was proved to be right, that the education bill was upheld by the Supreme Court, except that they were not in power. And this is how the power under the Constitution was sought to be used for a nefarious purpose of working against the opposition party. Now, once the education bill was upheld and an advisory opinion by the Supreme Court was in favor of the government, is there anything to restore the government? There was no provision for restoring government. That were all too early days where the court was always apprehensive of interfering with the decision of the government, and the courts did not go beyond a point. The question came much later. In 1975, when Indira Gandhi declared internal emergency, which is never heard of, internal emergency only because to continue in power. She lost the election. The Allahabad High Court held that her election was corrupt practice and therefore she cannot hold the office. She filed a writ petition in the appeal in the Supreme Court, election appeal, and Justice Krishna Iyer was hearing that case, refused to grant stay. He said she can attend the parliament, but she cannot vote in the parliament. This was a peculiar situation where a prime minister can go to the parliament, cannot vote in the parliament. This is something new. Therefore, she knew the demand for her resignation was increasing, and different opposition political parties have come together under a banner where we will not allow this dictatorial practice of the government, and therefore they started a campaign for demanding the resignation of Indira Gandhi. As a counterblast to this move, Indira Gandhi felt that India is Indira, Indira is India. That was a slogan at the time they were making, that one individual identified the whole country. And now what happened was, she declared the emergency. Consequently, all the opposition leaders were arrested. Comrade AKG was in jail, Comrade Jyotirmoy Basu was in jail. Under which law? Under the Maintenance of Internal Security Act, MISA. MISA of 1971 is the most darkest law which India has ever seen, because there is no trial, there are no charges against you. Because the district magistrate says that you should be in jail, you are kept in jail, that's all. The satisfaction of the district collector is more enough. Later, after the emergency, when the commission of inquiry was held by Justice Shaw, J.C. Shaw, he found in his report, it was a 5-volume report, somehow the report was not well spread out. But the nefarious and diabolical action of the Congress government was seen in the report. Recently, a Tamil Nadu politician has published that report, a contents report. One chapter talks about how opposition leaders were detained. There are district magistrates were given blank warrant and they had to fill up the name and they were put inside. Now, when there is a wrong order passed, normally we go to the court. When a detention order is made, when you are detained in jail, the only remedy is going to the High Court with a habeas corpus petition. In an habeas corpus petition, when a person is illegally detained, he can go to the court and say, why I have been detained. The court can say that this cannot be allowed anymore. That's one way, one method of number of people who are detained. Advani was detained, Vajpayee was detained, and Modi was there 21 months in jail. And Lalu Prasad Yadav, he was also in jail in MISA. When he came out, he had a daughter, Bharati. Now she is called Misa Bharati because she was born when Lalu Prasad was in jail. Now MISA became such a notorious thing. When people moved the High Court with a petition for constitutional relief of habeas corpus, some of the High Courts, like Karnataka, Madras, Hyderabad, several High Courts were willing to listen to these cases. During emergency time, the fundamental rights were suspended by the government, saying that you cannot move the court. But notwithstanding that, some of the High Courts were started issuing habeas corpus. The central government, ill-advised, moved the Supreme Court and said all the High Court cases will be transferred to the Supreme Court. The matter was heard by 5 judges. By judges' name I need not say. One is Mirza Afzal Beg, Y.V. Chandrachud, Bhagavati. There are 2 others. Now, why these 3 names I am saying, because I will come to later. Now, these 5 judges, they were hearing, during emergency time, if fundamental rights are suspended, can a person come to court? The Attorney General of India, Mr. Nerende, was defending the Union government. Judges put a very innocent question. Suppose a person is shot dead by a district magistrate. Cannot a person come and say, I have been wrongly shot dead. My life has been taken away without due process. And Mr. Nerende was heard saying that during emergency, whether you are illegally killed or legally killed, you can never come to court. This was the position taken by the central government. Today, Today, whatever you talk about governor or federal rule, the seeds of deviation was sown by the Congress government. Therefore, the Congress is inseparable from laying down such black role at those times. The bench, the 5-judge bench, which heard the matter, finally dismissed all the cases, saying that you cannot come to court. The result was all the leaders were in jail for 21 months, and after 21 months, and one of the judge, Mr. Chandru, whose son is a Supreme Court judge, he wrote that council after council are complaining about ill treatment of detainees in jail. I have a diamond heart hope such things will never happen in future. This is something which is strange, that every lawyer who argued pointed out how the detainees were ill-treated in jail. Even DMK detainees were beaten up in Madras General Jail, and later there was a commission of inquiry, Ismail Commission, and found that all of them were beaten in jail by the jail officials at the behest of the Congress party which is outside. Therefore, this saddest part of this judgment was no such ever judgment has ever been given before, and it is considered to be a black day for the Indian judiciary, because for the first time the court said there is no judicial review at all. Leave aside whether governor order or a district magistrate order, and one of the constitutional experts said that habeas corpus, remains to add, habeas corpus is the most glaring instance in which Supreme Court of India suffered most severely a self-inflicted wound. The wound did not come from outside. Nobody compelled them. They could have decided differently. Because one judge, Justice H.R. Khanna, said judicial review is available. And his brother's son is a judge now. And what happened to Chandrachud's son, Mr. Janardhan Chandrachud, who is number 2 in the Supreme Court, recently in the Aadhaar card case said that this judgment given my father is a wrong judgment. So the son now said father is wrong. So many peculiar things have taken place. But most important was, after the removal of the emergency, when elections were conducted, the central parliament was captured by the coalition of opposition parties, which came in the name of Janata Party. When Janata Party captured the parliament, first thing they did was, they asked, at that time the Home Minister was Charan Singh. Charan Singh wrote to all the state governors that since we have won in the parliament, you are continuing to be a state government party is wrong, because you no longer hold the will of the people. It is very strange, because people can elect one government for state government, one for central government. For each election, there is a state election, there is a union parliament election. Now the strange logic was, if you lose parliament, you must lose your state government also. Now when Charan Singh wrote to the governors, in where eight governors, where Congress party was in rule, they refused to send a report, saying that we will not send a report, because they were all appointees by the previous government. So they were still owing loyalty to the government. They refused to send any such report. Next point was, all the 8 governments were dismissed. Reason was not law and order. Reason was not constitutional framework. The reason was, in parliament election, Congress lost, therefore they cannot continue in state government. Now all the state governments filed for the first time a suit before the Supreme Court under Article 131, where the state can sue the Union of India. Recently also Kerala government has filed a suit against the central government under 131. A union government can be sued in the Supreme Court, and Supreme Court is authority to resolve a dispute between state government and the union government. Now when the case came before the Supreme Court, the very same judges were there here. Those who decided the earlier Misa case, they were the judges here, majority. Now what did they do? They found out the holocaust of the emergency. They found out the emergency excess. Therefore, they wanted to support the Janata government. Previously, they supported the Congress government. Now, when Congress was lost and Janata became the major government, they supported the Janata government. They said the dismissal is valid. That's the first time a provision which is not in the Constitution, a provision for which there is no mechanism in the Constitution, that if you stand in the parliament election and if you lose, you will also lose your state government. This is something very strange. And that was upheld by the Supreme Court in state of Rajasthan case in 1877. Nobody ever thought that the court will do. But one magic thing took place in that case. During the hearing, when the bench was constituted, it was a 7-judge bench. At that time, Justice Krishna Iyer was a judge in the Supreme Court, so he was asked to be in the bench. And Krishna Iyer was being a victim of a presidential dismissal order. He was a cabinet minister in the EMS government in 1957. He told the Chief Justice very honestly that I am a victim of your dismissal. If I sit here, people will not believe. They think that I am biased, therefore I will not be in the bench. It is a very great loss. But the remaining 7 judges upheld the dismissal of the 8th government. One of the judges, who is from Assam, Justice Goswami, he wrote in his order that during the hearing of this case, the Chief Justice told them that the Vice President of India met him in a function and told him to take care of the government. This was found in a judicial order. And then the Chief Justice was shocked because he could not give a reply in the order itself. This was written in the judgment itself, that he wrote that, this is what he said, I part with the records with cold shudder. The Chief Justice was good enough to tell us the acting president saw him during the time we were considering the judgment, after having already announced the order, and there was mention of this pending matter during conversation. I have given this revelation the most anxious thought, and even the strongest judicial restraint which a judge would prefer to excuse, leaves me no option but to place this on record, hoping that the majesty of the high office of the President, who should be beyond high watermark of any controversy, suffers not in future. This is there in the judgment itself. Not that Goswami decided against the government, but he decided against the Chief Justice, who happened to mention that the Vice President of India met and told him about this case. So going to the chamber or going to the house and mentioning about the case was, they started from 77 itself. But what is important was, the Chief Justice was very embarrassed. So he gave a press release. There is a 7-judge bench judgment. He gives a press release saying that I never spoke anything about that except had some pleasantries about some family function. Beyond that, I did not. That is also there published, and it is very regrettable. He complains about Goswami. It is very regrettable that Justice Goswami should misunderstood the Chief Justice, who was only anxious that the reason should be delivered before the court closes so that the judges are not placed in any embarrassing situation during the vacation. Now, this is the press release given by the Chief Justice. Now, for the first time, you will see slowly a political interference in the decision making has started in a starting point. I would only say the starting point of a political interference during the emergency was further continued. During emergency, judges who did not toe the line, judges who were willing to do judicial review, they were all pushed off to various places. Justice Chinnappa Reddy was transferred to Punjab. Justice Rajendra Sachar was transferred to Assam. People were punished during emergency. Therefore, the judiciary was made to follow the line of the ruling party. And that was the reason why this 1977 judgment came to be delivered. What is good for Janata Party is also good for Indira Gandhi. After emergency, when the Janata experiment failed, Indira Gandhi came back to power in 1980. She also dismissed 8 governments. There is no governor report. The only reason was that the Janata Party lost elections in various, in the parliament, and therefore they have lost the will of the people. Now, what is sauce for the goose became sauce for the gander. What is good for the Janata Party, also good for the Congress. Therefore, we will find one reason that alternatively, the Congress and BJP were playing the same game of perverting the Constitution. That's more important. The perversion of the constitutional principle, the constitutional morality started with the game played by them. They have no scruples. They have no respect for the Constitution. And therefore, when we discuss about governor, we can't forget the background news of this. This is most important. And later the question came during 1991, when the Babri Masjid was demolished. Narasimha Rao was in a fix. And Kalyan Singh, you know what happened. Kalyan Singh was the UP Chief Minister. And everybody was apprehensive that the RSS, the RSS people are mobilizing in a big way in Faizabad. And therefore there was a complaint. And the police is also warning the government that there may be something happened. Somebody went to the Supreme Court and filed a petition, please save the Babri Masjid. And Supreme Court issued notice to the Chief Minister of UP, who filed an affidavit that I will see to it that Masjid will not be dismissed. And later the Masjid was dismissed. On 6/12/1991, you can see the Sangees in saffron clothes with a crowbar hitting on the old building which is 500 years old, and it just collapsed. And when this collapse took place, Kalyan Singh was ordered with a contempt notice that you gave us an assurance that how is that the Masjid is dismissed. So he said, sir, it's beyond my means. I tried my best, but I was not aware such things are happening. So the Supreme Court gave a very peculiar punishment to Kalyan Singh. In the contempt, they gave him a punishment of imprisonment till the raising of the court, which you will find very laughing, because it's like a joke. What is till the raising of the court? I come to the court at 11 o'clock. I go out at 1 o'clock for my lunch and come back at 2 o'clock. Then I leave at 4 o'clock. So 4 hours, 5 hours I'm in the court. Now I tell the Kalyan Singh, you sit here. Evening you can go home. You watch our proceeding, go home. Is that the punishment? But whatever it is, a sitting chief minister was punished by the Supreme Court for giving a wrong undertaking. Now what really happened later was more important. Two things have happened. One is now, after the death of Kalyan Singh, Modi Shah has given him the Padma Shri Award. For what? For watching the masjid being demolished. Now, there is no respect for any constitutional norm in this country, especially after the BJP has taken power. That's the most important lesson that we'll have to think of. First one, that when a chief minister who has been punished by the Supreme Court, he has been given a Padma Shri Award. You can give any award, Bharat Ratna award also you can give. Nobody stops you. But what is important is that shows your scant regard for the constitutional setup in this country. The second thing that took place was, before the demolition of the Babri Masjid, Advani was on a Radha Yatra. In that Radha Yatra, in most of the places, he said two things, that constitution cannot solve all the problems, number one. Number two, the court cannot be the arbiter of all disputes of the people. The issue of faith can never be considered in any other manner. Now the issue of faith, which is mentioned by Advani, got reflected later in the Ram Janmabhoomi case, where 7 judges heard the case of Ram Janmabhoomi dispute, which has been going on for more than 100 years, and finally passed an order. The dispute started as a title dispute. If you have a property, you must have a title. The title must be by way of some document. The document must be an original document, not a forged document. So that is how any court can decide. But the Supreme Court, 7 judges benches, for the first time applied a theory that 500 years of faith of the majority religion proved by oral evidence, by their faith, that there has been a continuous worship of Ram. Therefore, the property should be given to that one side, the majority Hindu side. Then they will have to form a trust, which will be formed by the central government. And the trust will be exempted from income tax. Now the trust is there, so much money is flowing, the temple is coming at the base of the demolition. Where does this idea come in? Even though 7 judges have passed the order, the author of the judgment is not shown in that order. It's a strange, a unanimous judgment, but an anonymous judgment, never heard of. There must be an author for a judgment, but all of them signed. And the last paragraph says that we believe by the available oral evidence that is let in, that the faith of the people in offering worship in this place for the last 500 years is proved, and therefore the property should be given. If the majoritarian faith is a criteria for deciding, then why should we have a constitution? Why should we have a Supreme Court? Why should we have 7 judges saying all this? Now the light that has been set in, the fire that has been stoked, you find reflections in Mathura, you find reflection in Varanasi. Now people have started filing cases not in Supreme Court, starting with the Municipal Court. That's how the Ram Janmabhoomi started with the collector, and it went on. Now they have started again. Now there is a real danger of dividing this country in the name of the majoritarian faith, in the slogan that the Constitution cannot answer all these questions.